On the record in the matter of the people of the state of Michigan versus James Lackey, 5-00115. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Robert Palmer, Public Defender's Office, on behalf of Mr. Lackey. The gentleman is to my right.
Date that was scheduled for preliminary examination. I have a criminal sexual conduct in the third degree, 2 counts, and a domestic violence. Are we continuing to examine today?
Your Honor, the people are going to need to request an adjournment on this. Reason being is just last night, we came into very good and credible information that indicates that the defendant may be in violation of his bond conditions. So we would be seeking an adjournment so that we can pursue that matter.
How would he be in violation of his bond condition?
Well, I spoke to the victim last night to talk to her about her availability to be present, and she informed me that she and the defendant were actually trying to work things out, and they had recently moved back in together. So it sounds to me like the defendant may be in violation of his no contact order.
And I'm assuming she did not appear today.
And she's not present.
Counsel.
Judge, obviously, I'm objecting to any adjournment. Mr. Lackey and I are here present this morning, prepared to proceed to preliminary examination. I will point out a couple things. First of all, Mr. Nagel did inform me of his request prior to coming on the record this morning, but I would note this is a reissue of a case that was previously before at least the 54A District Court back in the fall. The case was dismissed at that time because the complaining witness did not appear. My understanding is that without making any comment on whether Mr. Lackey has moved back in, first of all, he advised me that that's not true. But without making any comment about that further, my understanding is the complaining witness has already contacted the prosecutor's office saying that she does not want to pursue charges. She does not want to go forward. As I say, she failed to appear. I wasn't representing Mr. Lackey at the time previously. She failed to appear previously. She's again failed to appear today. Now we're talking about adjourning again so that we can compel this witness who doesn't want to proceed to come to court to apparently testify about things that she doesn't want to testify. I would ask that the matter be dismissed today for lack of probable cause, as Mr. Lackey has a right to a preliminary examination within the timeline as the court is aware.
It is true, Your Honor, that this is a reissue. And based on the notes from the prior time it was issued, it does sound like it was dismissed for the same reason, but it is worth to note 2 things about that. One, it was reissued apparently because the victim had contacted our office and asked us to do so. And 2, her availability today, her not being here, but she did inform me that she and the defendant are in contact. I don't know what's going on at home. I don't know what kind of conversations they're having. I don't know if this can turn into a corporate wrongdoing. I don't know.
Well, based off what you're saying, it doesn't sound like they've been in contact. Sounds like they're together and he's moved or is moving back in. I will say this, seeing the date and time of the election incident, knowing that this was a matter that was issued and then dismissed because the witness failed to appear, and then now reissued because the witness has asked for it to be reissued, and then witness makes contact again with the prosecution indicating that they're back together. It appears to me that there could be the potential for some kind of tampering with the witness, because there's a no contact order during the pendency of the case. That is to avoid anything that might prohibit or discourage a witness from coming forth with valid allegations. At this time, I don't know if the allegations of criminal sexual crime and domestic violence are truthful or not. This is a matter that's been brought forth twice already, and based on the statements that, where are you living, sir?
I'm in that 3325 Barberville.
Clear, Judge, that is the address that's listed on the complaint. The allegation was that she was staying with him. She didn't live there at the time of the.
Let me tell you, Your Honor, she was living with me, right? Then she moved out. right? But after the case was dismissed, we was talking to each other back and forth, right? About getting back together. We had an incident where we got into an argument about some money. And she called the police and talked to them. I just found out about the reissue yesterday when I talked to him. I didn't know what the reissue was about.
You mean a reissue of what?
The
Yesterday?
warrant. When I talked to my attorney yesterday, I didn't know.
You knew about this
Last week.
before yesterday?
Yeah, I knew about the one, but I didn't know why it was reissued. That's what
Oh,
I'm telling
okay.
you.
Oh, you didn't know why they re-brought the case?
Correct.
Okay, got it.
Because it was, she never brought anything to my.
She never
attention
mentioned to you.
about anything.
Right.
And she doesn't live with me. I live by myself. Yeah, we talked about before the case got
That was
reissued. that we-
before the reissue.
Yeah, we was talking about getting back together.
I don't know what to tell you. Your witnesses doesn't want to appear. We can't keep dragging people in the court on some serious charges. This is criminal sexual crime. And the allegations, at least what I see in the affidavit of probable cause, is that the incident or the allegations took place while they were in a relationship. So, but with that being said, I grant the motion to dismiss without prejudice.
Thank you, Your Honor.
Mr. Austin has competency.
Are we gonna be waiting on Mr. Dennis to be brought up for the competency hearing, Your Honor? I think we're just gonna be setting it for an exam. I don't know if we need him for that.
It's up to his attorney if he wants to waive his appearance for that purpose.
For Dennis, do we want to waive?
Mr. Dennis here in person or is he on the video?
He's supposed to be on Polygon. He's not here yet, though.
It's whatever you want to do. I didn't, because we're gonna set it for the exam anyway. I didn't know how you want to.
It's fine, I'm fine with waiving the hearing for that.
Okay, I'm good with that. Yep. We're just, and then we'll come back.
Already.
The court would accept the waiver, Your Honor. I think we're ready on Dennis.
On the record in the matter, the people of the state of Michigan versus Brent Dennis 25-0004 FY. Appearance for the record.
Good morning, Your Honor. Matt Nagel for the people.
And good morning, Your Honor. Jared Austin appearing on behalf of Mr. Dennis. I believe we should have two files on the docket for the competency review. Mr. Dennis is currently lodged at the Ingham County Jail. I would be willing to waive his appearance for the purpose of this hearing.
You are correct. I also have 25-00038. Excuse me. I do have a competency. I should say, I do have a report from the State of Michigan Department of Health and Human Services Center for Forensic Psychiatry. It's dated for February 13th, 2025. Did both parties receive a copy of this report?
I did, Your Honor.
I have received a copy of the report, Your Honor, and I've reviewed its findings with Mr. Dennis.
Okay, the examiner has opined that the belief is that the defendant is now competent to stand trial. Is there any objection to the body or the conclusion of the report?
No, Your Honor.
I have no objection to the conclusion in the report, Your Honor. I would not be objecting to its findings. I would just ask the court to enter an order on each of the files consistent with the findings of the Forensic Center, set each of the matter for preliminary examination, I will not be seeking an evaluation at this time. I do have a couple of proposed orders, Your Honor.
What is today's date?
27.
Oh, right, sorry. Okay, I do have an order. Both files will be signed and dated for today. The body and conclusion, the body of the report will be incorporated to the file for the court record. This matter will be scheduled for a preliminary examination. Do you need a probable cause conference?
I don't believe it's necessary, Your Honor. I think we get to set the matters for preliminary examination unless the court or the people have an objection to proceeding that way.
No, yes, Your Honor. Exam sounds good to.
April 4th at 8:30. April 4th at 8:30. Any additional matters for today's record?
Nothing.
Nothing additional on behalf of Mr. Dennis, Your Honor, at this time. Thank you.
Thank you. You're all set. Okay, on the record in the matter of the people of the state of Michigan versus DeShaun Alexander, 25-00335.
Your Honor, I'm sorry, this is gonna be, this is Natalie Maycomer's case. I have not seen Ms. Maycomer yet this morning.
The expectation that we're running an exam on this.
That was the expectation.
Reach out to Ms. Maycomer, let her know the code report is ready. In the meantime, I think is Mr. Blackman.
She's in custody. She's right over.
Oh, gotcha, okay.
Your Honor, just one other note. Defendant case with the two Moores and Ms. Stevens. That is going to be a waiver of the exam with the two co-defendants choosing to represent themselves.
Sounds good. I'll handle that while we figure out where Ms. Maycomer is on the 8:30 matter.
I apologize for that.
Well, it's not your error. State of Michigan versus Darian Moore versus Darius Moore and versus Sienna Stevens. 524-0328586 and 87. Council Karen.
Good morning, Your Honor. Robert Hayes, Assistant Attorney General, here for the people, P69006.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Darius Moore, who is standing to my right.
Okay, and state your name.
Darius Moore.
State your name.
Darian Moore.
State your name. Okay, and Darian Moore and Ms. Stevens, you're representing yourself today?
Yes, Your Honor.
Okay, so today was the date and the time that was scheduled for preliminary examination. And Mr. Goodrich said that your client is going to waive exam.
That is correct, Your Honor.
An offer on this.
Yeah, there's not an official offer at this time. I have been in discussions. I also have had an opportunity to speak with Mr. Moore and Ms. Stevens with Mr. Goodrich present, just for appearances. And we did have an opportunity to discuss. I kind of gave them the facts of the case, gave them the idea of what the preliminary exam was about and why one may or may not hold the preliminary exam. They have expressed that they are interested in waiving their rights to a preliminary exam today. I have gotten their contact information now, so at this point, they will be able to have open lines of communication with me if needed. And I anticipate providing an offer once we get the circuit court to all three.
Okay, Mr. Darion Moore,
Yes, Your Honor.
representing yourself today, you've been given an opportunity to seek counsel. You've appeared without counsel, so you're waiving your right to be represented by an attorney today.
Yes, ma'am.
Okay. Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Okay, you understand that you're being charged with felonies in this
Yes, Your Honor.
case? Okay, and you're being charged with gambling activities, a felony violation that carries a penalty of 10 years and or $100,000. Count two, computers using to commit a crime, a felony that carries 10 years, $10,000. And then computers using to commit a crime, and count three, felony, 7 years and or $5,000. And here, and count four, embezzlement, felony, 5 years and or $10,000 in fines. You understand the charges that you're facing here?
Yes, Your Honor.
And do you understand the purpose of the preliminary examination?
Yes, I do, Your Honor.
So you have the right to require that the prosecutor, which is the office of the Attorney General, to put forth evidence on the record that would establish that they have sufficient probable cause that the felonies were committed, and then sufficient probable cause to charge you as the person who committed the felonies. You understand that, right?
Yes, I do, Your Honor.
Okay, you want to give up your right to have that examination?
Yes, I do, Your Honor.
Is anyone threatening you to get you to do that?
No, Your Honor.
Has there been any promises extended to you to get you to want to waive your examination?
No, Your Honor.
And you understand that the waiver is unconditional. You cannot get to the circuit court, feel like you're in over your head, or later find the money to get an attorney and get counsel that maybe you shouldn't have waived it, and then decide that you're gonna have your exam. Once you waive it, it's gone. You understand that?
Yes, I understand, Your Honor.
And then Ms. Stevens, you have an opportunity as well to hire counsel, correct? You had an opportunity to hire an attorney, correct? Okay, and you've not appeared with attorney. Are you waiving your right to counsel? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? Yes. Okay, you have count one, gambling activities, felony violations. It's a 10-year and or $100,000 penalty. Count two, computers used to commit a crime, a felony, 10 years and or $10,000. Count three, computers using to commit a crime as a felony, 7 years and or 5,000. And you have a count four of embezzlement, agent or trustee, which the maximum penalty is 5 years and or $10,000. You understand the charges that you're facing here? You understand the maximum penalty in each count? And you understand the purpose of a preliminary examination? So you have the right to require the AG put forth evidence that would establish that they have sufficient probable cause that these felonies were committed, and then probable cause sufficient to charge you as the person who committed them. You recognize that? You're willing to unconditionally give that examination up? Anyone threatening you to do that? Any promises being extended to you if you give up your exam? Okay. Need everybody to sign their paperwork.
Hearings.
Yeah. Oh, I'm sorry. Prosecutor, you said I did that.
Okay.
Do you want the? I tried to keep them all. So you can just.
Oh, it's fine. Thank you. Okay. I find your waiver to be freely and voluntarily given. Your matters will be bound over to the circuit court for a bind over date of March 12th. That's the date the circuit court gets the file from the district court. You do not have to appear in circuit court on that date. Ma'am, are you okay? Okay, so where are you looking off over there? Because I'm giving important information to you.
I'm listening.
Okay, I need to see that you're listening too. Because if you're staring off into space, I don't know if something's going on, okay? I recognize it's a lot of information, it's pretty heavy, and you're representing yourself right now. But let me understand that you are listening so that I don't need to see if I need to order counsel to further engage with you before this case gets bound over, okay? Okay, okay, so you do not need to appear in circuit court on the 12th date. That's the date that they'll get the file from the district court. The next court date will be set after they get that date. There'll be a date for a pre-trial. So because you're representing yourselves, you'll need to make sure you stay abreast of your mail so you know when that date comes, okay?
Yes, Your Honor.
Okay, and then your attorney will be notified of that date, okay?
Understood.
Okay. Do you have any questions for the court?
No, Your Honor.
Ma'am? Okay, a bond for Darius Morris, 5,000 personal recognizance, it will continue. Bond for Miss Sienna Stevens, 5,000 personal recognizance, and that will continue. And bond for Mr. Darian Moore, 5,000 personal recognizance, that will continue. Any additional matters for the record, counsel?
No, Your Honor. They are listed as co-defendants on the complaint, I believe, so that we should all be together, hopefully.
They should be all together.
Nothing from the attorney for Mr. Darius Moore.
Thank you. You're all set.
Thank you, Your Honor. Thank you, Your Honor.
You're welcome. So I guess I. No.
Great. I think so, Your Honor, we are ready on Della early if the court is. Can we approach her?
I'm totally doing something right now.
Oh, sorry. This is why I sometimes just.
So you look up.
You know, all I gotta
know
say
you're
is you
busy.
blame the defense attorney for that one, Your Honor. Mr. Nagel had nothing to do with that assumption or presumption. But I could sing if you'd like.
That wouldn't help it.
Okay,
Not at all.
would it
Not
hurt
at all.
it?
It might.
Okay.
It
well, I'm
might
just gonna
hurt.
Go ahead and mind my business and stay in my lane. No, she sings like an angel. I sing like. Yeah, give me 5 minutes.
So working on his case section.
It's his fault, Your Honor.
Oh, it's co-defendant, so. This is- Which matter is Mr. saying on?
Mr. Abdullah.
To Ms. Maycomb.
She's on her way. She'll be here in the next few minutes. Your Honor. She just said this. Your Honor, if I can check the Holy one more time. I spoke to the witness on Tyler yesterday. She told me she was going to be here on Anthony Tyler.
Anthony Tyler.
She told me she was going to be here, but her tone told me to expect otherwise. So I just want to check real quick and see
Sounds
if
good.
she's here.
Yeah. Mr. Goodrich has Sierra Robbins.
Yes.
Are we planning to run that?
Well, we were planning to ask for an adjournment for discovery purposes, and I think Mr. Nagel was planning to propose that adjournment request and just wanted to run the executive.
Okay, we'll wait till he's available. Next is Tyler.
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Anthony Martin Tyler 25-00323. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Edward Zany on behalf of Mr. Tyler is present to my right. Your Honor. Good morning.
Okay, Mr. Tyler was scheduled for preliminary examination today. Are we prepared to run an exam?
Your Honor, necessary witness is not present this morning, therefore the people are unable to proceed. Due to that, I expect defense to make a motion.
After Your Honor, we have to court dismiss the matter.
A motion is dismissed without prejudice. The people do have the right to reissue the charge against you. Do you have any questions at this time? Okay, we'll get you a copy of dismissal. Any additional matters for the record?
Okay, no, Your Honor.
None from the defense, Your Honor. Thank you.
Thank you. Is Mr. Goodrich still here?
Thank you.
Or did he step out?
I think you just stepped out, Your Honor. You didn't.
Oh, okay, yeah. I need some. Your exam, Your Honor.
Good weekend, everyone.
Thank you.
I suspect that's what you're.
You're gonna have to be in the hallway.
Sienna Stevens, we did Sienna Stevens, Mr. Rich, I asked you about some of these
Robbins,
were
Ms. Robbins.
okay. Sierra Robbins. This is the state of Michigan versus Sierra Robbins 25-00116 FY. Thanks for the record.
There you go.
We wanted to ask for to wait 20 days and adjourn it for discovery. I'm just kind of against that.
Good morning, Your Honor. Natalie may come on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Ms. Robbins, who's standing to my right.
Okay, today was the date scheduled for preliminary examination on a weapons carrying concealed. My understanding is that there was going to be an adjournment request.
That is correct, Your Honor. The defense would ask that the matter be adjourned at this time. My client's willing to waive for 21 days in this matter because
basically our whole crux of our case is whether or not there was reason to search a vehicle.
Oh.
And we were requesting a body cam video from the officer. We have not had a chance to receive that as of yet. So we would just ask that this be adjourned so that we have time to review that prior to preliminary exam. That's like really the whole crux of our case.
Makes sense.
Your Honor, my officer is present. I was just looking for her. She just came up. My officer is present. We're ready to proceed with the exam today. Counsel is welcome to cross-examine the officer on anything that could be potentially in the body camera. As the court knows, complete discovery does not have to be finished prior to the exam. I have not seen the body camera footage either. I only have 5 photos of the gun itself. So people would prefer to start the exam today.
However, there's evidence that might be exculpatory is what he's trying to get.
Yes, regarding the search that found the gun.
Okay. Motion is denied as to your objection, that is, your motion is granted. I'm going to find good cause based on the request. To adjourn to allow the discovery body cam footage to be turned over. And then, is it your expectation, Mr. Goodrich, that if you get this body cam and it has some information that you're gonna file a motion, or you just want a new PED?
Just a new PED.
Okay, so Ms. Robbins, you have the right to have a preliminary examination within 21 days of the date that you're arraigned. However, because your attorney is seeking additional discovery prior to moving forward, we're gonna find good cause to go beyond that 21 days, so this matter can be reset, okay? Do you have any questions? Okay.
April 4th at 9:30.
April 4th at 9:30. Any additional matters for the record today?
No, Your Honor.
No, Your Honor. Thank you.
Thank you, you're all set, we'll get your notice.
For discovery, you can.
Mr. Palmer, so. I think it's that we're supposed to treat this
I'm
as a
sorry.
piece and
If you wasn't assigned at the time.
right, I just want to know if we can waive the date and give them a new date.
Yeah, no, I spoke to the officer last night.
Oh, okay. On the record in the matter of the state of Michigan versus Kayla Martinez-Wisman, 25-00385. Councilman Simmons.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Robert Palmer, Public Defender's Office, on behalf of the defendant who is approaching the table.
Today was scheduled for a preliminary examination that I have a note that we're treating as another probable cause conference because counsel had not yet been appointed. And now Mr. Palmer is appointed, so are we ready to set a new date or do you need the discovery?
No, Judge, I think I have all the discovery. I've received report. I've received all the videos, so I think we're ready to set it.
Okay, so on this Martinez-Wisman, you had the right to have your examination within 21 days of the date that you were arraigned, but your attorney was recently appointed, and so there's more time that was necessary to get him on the case and to have him prepared to proceed. So we're gonna find good cause to go beyond the 21 days. That allows me to reset the matter for a new date, okay?
Yes, ma'am.
Do you have any questions?
No, no.
April 11th at 9:30. April 11th at 9:30.
Judge, I'm actually scheduled to be out of town the 10th and 11th. That's okay. Can we have it?
April 17th.
April 17th works. You said at 9:30.
Yes. Okay, bond will continue. Any additional matters for the record?
No, Your Honor.
No, Your Honor, thank you.
You're all set for today. We'll get you on your notice. You're welcome. Okay, let's see, did I take care of all the line? No.
technically,
Shakir,
yeah.
Rogers, Jameson. Here. Have you been?
He called the clerk's office.
Oh, he's running late?
Oh, I didn't
Call the
know that.
clerk's office.
Oh, gotcha. All right, then I guess he's running late.
Okay, sounds good. So maybe he'll be here after this next. Let's see.
Sounds good, Judge. I'll just wait. I'll wait for him.
On the record, in the matter of the people of the state of Michigan versus DeShaun Alexander. 5-00375.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Alexander, who is approaching the desk right now.
The table is the date scheduled for preliminary examination. Reference complaint. Ready to proceed.
People are, Your Honor.
Yes, Your Honor.
Preliminary matters, we all witnesses.
And I just like to remind the court that at the preliminary or the probable cause conference, people did bring up that we may have to ask for continuance after proofs today. I do believe that we'll be able to provide the court with enough information for probable cause bind over, but if not, we'll be asking the court for continuance for that other witness that was not available today. Further, I do have one exhibit that I will need to have marked showing its defense right now. It'll be people that one.
Yes, we would stipulate to it.
Your Honor, exhibit one, if I may push the court now, is just the certified conviction of Mr. Alexander's prior conviction of the specified felony. Any public questions? Yes.
Completely full, nope.
Some more.
So. I do need some more.
Okay. Your Honor, the defense would also ask for a sequestration order in this matter. I would state that one potential witness that we may call Nuhan Lee may be called to testify.
You say you may call a witness today?
Yes.
Okay, sequestration is granted. Any other preliminary matters?
Not from the defense.
Okay. Call your first witness.
Thank you, Your Honor. People call Officer Melinda Hutchings.
Solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes.
If you can have a seat. And state your first and last name and spell both.
Melinda Hutchings, MELINDA HUTCHINGS.
Proceed, counsel.
Thank you, Your Honor. Good morning. Where are you employed?
Lansing Police Department.
How long have you been with the Lansing Police Department?
It's about 6 years.
What is your current role with the Lansing Police Department?
I'm in the Special Operations section of the Regulatory Officer.
And working with the Special Operations Department, do you help on the execution of search warrants of residences?
Yes.
Were you working on February 6th of 2025?
Yes.
During your shift, did you have a reason to respond to 3211 Jerry Street, GEREE, in the city of Lansing, to Ingham County, Michigan?
Yes.
Was that for the execution of a search warrant?
Yes.
When you arrived on scene, were you the first officer on scene?
I was not.
Okay. Were you made aware if there were any civilians on scene? And who were you made aware was on scene?
There was one subject on scene.
And did you actually come into at least face-to-face contact with Mr. Alexander?
In passing.
Were you able to observe his appearance?
Yes.
Would you recognize him if you saw him again?
Yes.
You see him in the courtroom today?
Yes.
Can you describe where he's sitting in an article of his clothing?
He is wearing a white shirt next to the
There's that identification of the defendant.
No objection to the defense, Your Honor.
So noted.
Thank you. Were there any other civilians on scene when you arrived at 3211 Jerry Street?
Not that at all.
During your time at 3211 Jerry Street, what was your main role in response to that address?
My main role was assisting in the search of the residence.
Prior to the search of the residence, was the residence cleared?
Yes.
And were you part of that clear team?
No.
Did anyone that was part of the clear team assist you in the search of the residence, or are they two kind of separate teams that worked?
Two separate teams.
In your search of the residence, where did you search the residence at? Which rooms or room?
I began searching the bedroom and then I kind of just assisted in other places that they needed.
Was there only one bedroom in this home?
There was 3 bedrooms, only one had a bed in it.
So you were searching the bedroom with the bed in it.
Yes.
Were you able to determine by at least your observations if there were one or more persons that stayed in that bedroom?
It appeared that there was probably 2 subjects that stayed in the bedroom.
And why do you say that?
There was men and women in there.
And in your search of the bedroom, did you find anything that had any sort of names attached to it or names on it or documentation?
Yes.
What did you find?
There were pieces of mail on the dresser in the bedroom.
And who was that addressed to?
DeShaun Alexander, and then I also saw mail addressed to a female.
Do you recall that female's name?
I do.
What was that name?
I don't know how to pronounce it.
Okay.
Sorry.
If I spell it, would that help?
Yes.
Okay. That. I'm looking for the spelling of that name. In both female's mail and Mr. Alexander's mail, was that both addressed to the Jerry Street address?
There was mail that I remember for Jerry Street, and then there was an additional address that I can't recall.
Was the street on Conrad Street?
I can't recall.
That's okay. Going back to the female's name, was the last name spelled L-Y
Yes.
and the first name spelled N-H-U-N-G-H?
Yes.
And that mail is located in the same bedroom with that bed in it?
Yes.
What else did you find, if anything, in that bedroom?
I located a firearm and ammunition.
Were the firearm and ammunition together, like the ammo was in the gun, or were they separate or both?
The firearm was loaded without a round in the chamber, and then I located separate ammunition within the other parts of the.
Specifically as to the firearm itself, where, if you recall, did you locate that firearm?
It was on the left side of the dresser in the middle drawer.
Can you describe what this dresser looks like for the court?
So it's a pretty long dresser. It has drawers on the left side, like a middle cabinet, and then drawers on the right side.
And you said you found it on the left side,
Yes.
in the middle drawer?
Yeah.
Was there anything else in that drawer?
There was another box of ammunition.
And were there any personal items in that drawer?
Yes.
And what were there?
It appeared to be women's clothing.
In that dresser, were there drawers that had men's clothing as well?
Yes.
That same dresser with the three drawers on one side and 3 on the other?
Yes.
Did that drawer that had the firearm and box of ammunition, was that locked at all?
No.
Was it accessible if you just opened the drawer?
Yes.
Was the firearm hidden in any way, shape, or form under like a false shelf or anything like that?
Just under clothing.
Was the bedroom door locked when you arrived?
Not when I arrived. I don't know if it was locked prior to me getting there.
Was there any sort of mechanism on the dresser itself that you had to manipulate other than just opening the drawer?
No.
Fair to say it was easily accessible if you knew it was there.
Yes.
During the search of the home, did you actually interview Mr. Alexander?
No.
Did you overhear Mr. Alexander being interviewed at any time?
No.
Did you overhear any comments Mr. Alexander made to any other officers on scene?
Yes.
What did you overhear?
I overheard him saying that the gun was his girl's.
The gun was his girl's, you said?
Yes.
And to be clear, you didn't hear the entire conversation, is that fair to say?
Correct.
And the conversation that you did hear, did Mr. Alexander seem to be surprised about what he was speaking about?
No.
After you found the firearm and the ammunition, did you locate anything else within the home that was of note?
Personally, I didn't. Also within the dresser was 2 extended magazines.
And where, if you recall, where those located?
Those were in that middle cabinet.
Were there any personal effects, if you recall, in that middle cabinet?
There was.
And do you recall what that was?
I can't recall.
Do you recall if they could have been attributed to either the male or the female, or is it unclear in your memory?
Unclear.
The extended magazines, were they loaded as well?
One was and one was empty.
When you say extended magazine, do you know about how many rounds that would have held?
I believe they held 30. I think there was 29 rounds in one and the other one was empty.
After you located the firearm and the ammunition, the extended magazines were located, what happened with those items? Did you photograph them in any way?
Yes,
And what did you use to photograph them with?
my work cell phone.
As you were taking the photographs, did you check the photographs?
I did not.
Did you attempt to upload those photographs later?
Yes.
And when you attempted to upload those, what, if anything, happened?
I noticed that it appeared the settings had changed on my camera, which I think it turned it to the night mode because some of the photos ended up getting blurry and it was just like the flash that you could see.
Was there anything of substance that you could see within the photos that you took of where the gun was found?
Not that I recall.
Was the gun seized from the home?
Yes,
And then was it taken to Lansing Police Department headquarters for the quartermaster lockup?
it was taken to the operations center.
Operations Center, okay. And it was held in evidence there?
Yes,
Same thing with the magazine
yes,
and the ammunition?
yes,
And then the 2 extended magazines?
yes.
Were you with anyone else when you found the firearm and ammunition within the dresser?
My sergeant was in the room as well.
Which sergeant is that?
Sergeant Kevin Schlegel.
And did he end up taking photographs of the weapon at all, to your knowledge?
I don't know.
Other than the firearm and ammunition and the magazines that were found in the bedroom, did you find any other firearm and ammunition related objects throughout the remainder of the home?
I personally didn't. I don't recall any other being found as well.
Officer Hutchings, what other place, what all did you search in the house?
So I searched the bedroom that had the bed in it. I assisted in searching a portion of the kitchen, and then we kind of all went back to rooms again. So I assisted with like the other rooms that were in there and just.
Did you find any firearms or any other illegal contraband in the other rooms that you were searching?
No.
And the mail that you found, you stated that there was mail with Mr. Alexander's name on it,
Yes.
but that there was also mail. Do you recall, was the mail that had a different address on it?
I don't recall.
But there was mail there that had an address that didn't belong to Jerry Street, correct?
Yes.
When you first walked in, where was Mr. Alexander?
In the living room by the front window.
You said in the living room by what?
By the front window.
Okay, is that, I guess, near the bedroom in this residence, or how is it laid out?
So you walk in and there's a living room and then the kitchen's in the back. And then in between the living room and the kitchen is the hallway where all the bedrooms are. And so I was in that back bedroom.
Okay. But he was not in that bedroom when you entered it, correct? And you stated that the gun was found in a drawer with essentially women's panties and that type of items,
Yes,
and it was under clothing?
yes.
So when you opened the drawer, could you see the gun, or did you have to kind of dig through a little bit?
No, I had to move a couple items of clothing. Yeah.
Okay, so it was not visible if you just pulled open the drawer.
Correct.
And when you did most of the decor in the room appear to be female oriented, or?
To be honest, when I got in the room, it was pretty destroyed from it being cleared, so I don't recall seeing much decor in there.
Okay, so like I said, you weren't the first officer into that room,
Correct.
and other officers had kind of rifled through things a little bit prior to you getting in there?
Yeah, they cleared the room, so they like moved the mattress, pulled the dresser away from the wall, make sure no one was behind that type of thing.
Okay, so they did move things around a little bit before you even got to search.
Yes.
Your Honor, no further questions at this time.
Can you read that?
Officer Hutchings, of the mail that you had observed during the search of the residence that was addressed to DeShaun Alexander, do you recall observing a consumer's energy piece of mail that was addressed to DeShaun Alexander at all?
It was some type of utility bill. I can't remember if it was BWL or consumers.
If I showed you a copy of the report, would that help refresh your memory?
Yes.
I may approach the witness?
Yes.
Just read this top paragraph to yourself, look up when you're finished. Does that help refresh your memory?
Yes, that was a different officer.
Yes. Did you observe that piece of mail?
Yes,
Okay. And what utility bill was that and what company?
consumers.
It was addressed to DeShaun Alexander?
Yes,
And the address on that consumer's bill was at 3211 Jerry Street?
yes.
And just to be clear, and I understand that this may catch an objection for speculation. Ahead of time, I'll say this, but when you observed the clothing within the dresser, did it appear to you that there was clothing as if somebody stayed there more than just one set of clothing, or was there multiple sets of clothing within the dresser drawers?
Objection, I think, I don't know if it's clear, but I think that's calling for speculation as to how much clothing is necessary for more than one day or what we're talking about.
Let me get some clarification on, they're talking about the drawer that the firearm was located, is that the drawer you're talking about?
The dresser that the firearm was located, but there's different drawers.
It's also, you're not talking about that particular drawer, just the dresser in, okay.
Yes.
I agree that the way it's formulated, it could cause for speculation, but could easily just ask how many sets of clothes or something.
Yes, thank you, Your Honor. Were there more than one set of clothing within the dresser that were male clothing?
Yes, there appeared to be.
And was there more than one drawer that contained male clothing within that dresser?
I believe so.
And were there other either dressers or nightstands within that bedroom?
I can't recall.
Showed you a photograph from the search. Would that help refresh your memory?
Yes.
If I may approach. Read these to yourself and just look up when you're finished. That help refresh your memory? Was there any other nightstands or dressers located within that bedroom?
Yes.
And within, was it a nightstand dresser?
It appears to be a nightstand.
And within that nightstand, were there other pieces of mail or documentation addressed to DeShaun Alexander?
My sergeant searched that one, so I don't recall.
That's
There.
Nothing further.
This may be excused. Call your next witness.
Thank you, Your Honor. At this time, the people would rest with the understanding that if the court does not feel that we've met a burden, we would be asking the court then for a continuance to bring in the other witness. I did interview DeShaun Alexander for the statements made. However, I do think that by a couple of questions, we can make a binder argument at this time.
Defense calling witnesses.
Yes, Your Honor, the defense would call a Nuhan Lee. Right on up.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Have a seat. There's a microphone that's in front of you, and the purpose of that microphone is so that the lady behind you can take down everything that's being stated in the courtroom to create a record. That microphone will not amplify your voice, so I need you to speak loud and clear so that we can hear you. I need your responses to be verbal, so you can't do head nods or head shakes or mm-hms and uh-huhs, because we can't understand that accurately in the record, okay? All right. If there's an objection, you'll stop speaking so that I can make a ruling on whether or not the answer can be brought in, and then I'll tell you whether or not you can give us that answer, okay? State your first and your last name and then spell both. I'm struggling to hear you.
Okay, first name is Moon, NA2NGH, last name LY.
Okay, thank you. You can proceed.
Yeah, thank you. Ms. Lee, who lives at 3211 Jury Street?
I do.
When you say you do you live there with anybody else?
No,
Do you rent that place? Do you own that place?
rent,
You rent it? Okay. Are you the sole person on the lease?
yes,
And do you know who DeShaun Alexander is?
yes,
How do you know Mr. Alexander?
he's my boyfriend.
And how long have you been dating Mr. Alexander?
About 2 years and 3 months.
And has Mr. Alexander, does he ever visit you at 3211 Jerry Street?
Okay,
And I guess, how often does he visit you there?
that's like basically 3 times a week when I'm home.
And does he ever go there when you're not home?
If I ask him to,
Okay, why might you ask him to go there?
I have a dog that needs to be at access when I'm at work.
Where do you work at?
My warehouse,
And I guess what type of shifts do you work
I
there?
work third shift, so I go in from like 7 to 7 or 10 to 7, depends on if it or when they need me.
So is that is that nights essentially?
Yeah.
Night. Going back to the date of February 6th. Do you recall the date of February 6th?
Yes,
Okay, do you recall that your house was searched that day?
yes,
Were you home when the police arrived to
I
search the
I
place?
was not,
Can you give me, what were you doing on that day?
I was at work,
What time did you get to work?
about 7 o'clock, well, 6:30
When you say 6:37, are you talking about PM?
p.m.
Yeah, okay, so you got there in the evening. Did you have anything going on earlier that day?
Yes, I had a nail appointment,
Okay, do you know roughly what time your nail appointment was?
5 o'clock,
Now, Ms. Lee, do you own a firearm?
I do,
What type of firearm do you own?
a 10mm handgun,
And do you have a CPL or something that will allow you to carry that concealed?
yes, CPR.
And how long have you owned that gun?
I bought it in the summer, this summer, well, last summer, at an auction,
Where was that auction at?
based in Michigan.
Okay, was that the gun and knife show there?
Yes, sir,
And why did you buy a gun?
protection,
I guess, what do you mean by protection? What do you protection for what?
I think everyone should have one. Myself,
Okay. What was your kind of routine with the gun? Did you carry that around? Is that something that you frequently left behind, or what was your routine?
it's normally always on me, either on me or in my car, my vehicle that I drive.
Are you allowed to carry that into work?
No.
Okay, so when you're at work, where's the gun typically at?
In my car, in my purse, in my locker.
On this occasion, the police stated that they found a gun in your, why was there a gun in your drawer that day?
I forgot my gun that day because I had a nail appointment. My intention was to go back to the house and get my gun, but I got caught in the work and I had to be there at 6:30. And my appointment probably lasted like an hour and almost an hour and a half. So I rushed to work.
Okay, so between the nail salon and getting called into work, is it fair to say you didn't have a chance to stop at home?
Absolutely not.
Okay, and is that the reason that there was a gun in your residence?
Yes.
Why was Mr. Alexander at your residence at this time?
He was going there to let my dog in his cage.
Is that common for him to go over there to let your dogs out while you're at work then?
Yes.
At that point, you had already testified that you had been at a nail appointment prior to going to work, so had it been a few hours prior to you being home to let the dog out?
Yes.
Now, do you ever let Mr. Alexander handle your gun?
No.
Does he ever get to borrow your gun?
No.
Does he even know where you keep your gun?
Not that I know. No.
Hey, where do you normally keep the gun when it's at your house?
In my gun case, I have a gun case.
So you do have a gun case. Okay. Do you recall where you had left it on February 6th?
It was in my panty drawer.
Okay, why did you put it in your panty drawer instead of the safe that day?
I was just in a rush when I got home from work that day. I was really tired, so I just threw it in there and went to sleep.
Okay, what time did you get home from work?
About 7:20, 25.
Is that AM? So on that day, you just tossed it into the drawer because you were tired?
Yes, sir.
Was it your intention to get the gun out prior to leaving the residence?
Yes.
Do you ever, so have you ever, has Mr. Alexander ever seen where you put that gun?
No.
Does Mr. Alexander stay at your residence on occasion?
Yeah, sometimes.
Okay, does he have some items that are at your house? Do you know where he lives at full time then?
With his mother.
Okay, and do you know where that is at?
It's on Conway Street.
Does Mr. Alexander ever get mail at your address?
I do have a board of water and light bill in his name.
Okay, why would a board of water and light bill be in his name?
Well, he's my boyfriend. I had asked him to put my board of water and light bill in his name, because I had owed somebody on my old one.
Okay, so essentially you're kind of behind on under.
I needed my lights on, so yeah.
So you had somebody else do it? Okay, I understand. But did he get other mail at that address?
No.
Do you keep any extra ammunition for the firearm?
Yes, I do.
Okay, where do you keep extra ammunition?
It was something, either it should have been in my drawer, and in my gun case.
Okay, so are we talking about the same panty drawer?
Yes.
Again, do you ever show that ammunition to Mr. Alexander in any way?
No.
Does he, to your knowledge, does he know where that ammunition is kept?
No.
So in your experience, in the time that you've dated Mr. Alexander, has he ever had access to your gun?
No.
Your Honor, no further questions at this time.
A few thoughts, I'm sorry.
Thank you, Your Honor. Why was he? So that you've been dating Mr. Alexander for 2 years?
You have to change.
Some change, fair enough. He actually does live with you at the Jerry Street address, though, correct?
No.
In fact, there's not only a consumer's bill in his name here, but also a board, water, and light bill in his name there, correct? So both of your main utilities are in Mr. Alexander's name,
Okay.
and he stays there regularly. He does not stay with his mother, correct?
No, he stays the night in my house. Yes, when I'm at home, he's there with me, but I work a lot.
Isn't it true that he is currently staying at your home? He's not staying at his mother's home.
He stay there a couple nights, yeah.
That he lives there, and that he told you that he could live there, that only his mailing address had to be his mother's house.
No,
Isn't
he
that
never
correct?
told me that, no.
Do you recall speaking to Mr. Alexander when he was in custody on February 24th of this year, after he went into custody at the circuit court?
I do recall, but I don't know like what we talked about. We always talk.
You know that those phone calls are recorded? So if I were to play a call for you in which he told you that he didn't have to stay at his mother's house, he just had to have his mailing residence there, after you had told him he had to stay at his mother's house, would that refresh your memory?
No, not really. I mean, if I said that, then it meant like he had to stay there, so they told him he had to stay at his mother's house. So he couldn't stay in my house no more. That's
My question to you, though, was that he told you that he could still live at the Jerry Street address in that phone call.
not that I recall.
Your Honor, I believe she asked if that would refresh her memory. I believe the witness stated that no, it would not, so I don't believe it would be proper to play it at this time.
Not refreshing your memory, I'd be impeaching her at this point.
You know what I said, I didn't recall.
Well,
She
I
said,
don't remember.
she said not that, the question was whether or not she would remember it or whether or not she said it. Which one was the question?
I asked her initially if it would refresh her memory to hear that she did not recall that happening, because the answer is still an I don't know. The court will say that I can still treat that as a no and impeach her with that.
I think that my clarity is as to her response, because she says not that I recall. So I don't know if that isn't, no, I won't refresh my recollection, or no, I still don't recall. So do you recall what she's saying or no?
I recall what she said, but I don't know like what we talked about, his exact words to me. No.
Okay. But the question, I guess, to clarify is, are you disputing what she's saying was said?
I'm still not sure.
I'm sorry,
I'm still not sure what you're saying.
repeat your question to her.
Sure. would you disagree with me if I told you that what Mr. Alexander said in that phone call was that he can still live at the Jerry Street address? His mailing address just had to stay at the 801 Conrad with his mother.
I really don't recall what he said, but I told him he had to stay at his mom house because he was still staying night with me.
Yes,
And for what I understood that he had to stay at his mom.
I understand what you said, and I agree with what you said. My question is, would you agree with me that Mr. Alexander responded to you and said, no, I can stay at our house. My mailing address just has to be at my mom's
I
house.
don't recall that.
Okay, so now you're seeking to impeach your testimony.
Yes, Your Honor.
Okay, you're
I
objecting
would
to the
argue
impeachment.
that's improper impeachment because she's not saying that it didn't happen. She's just saying that she doesn't recall. The impeachment would have to be that in opposition to what she testified to.
Well, no, she can still impeach. I think even the way the witnesses responded, she's got very much so clarification as to what she said, but then she gets hazy as to what was said back to her. So I think there's grounds for impeachment. Objections are ruled.
And Your Honor, if I may, for sake, I will have to find the timestamp on this. I may move on with my questions and come back to that.
Oh, okay. Are you going to be needing to play this so I can give you access to Zoom? I don't know how you're going to impeach. I'm not sure.
I was just gonna play it on my computer. if
Oh, that's fine.
Okay. So if it's okay if I move on with my questions, then I will come back to that
Yes.
point. Lee, where would you keep your gun safe or your gun case? Underneath the dresser. Okay. And can you describe that gun case for the court?
It's black. It's small, it's like the size.
Okay. Have a lock on it?
No, it's the main guy, it's just closed. It has like kind of like a lock. I have to kind of close to it, but it is a lock.
Not a key, but a snap lock?
Yeah.
Okay. Black case, like probably a gray snap lock?
Mhm.
Okay. Would it surprise you to know that that case was not found by law enforcement in the bedroom?
Was not found by law enforcement?
Correct.
It should have been in there.
Okay. Would surprise you to learn that the police moved the dresser and still did not find that gun case?
Well, it should still be up under there.
And that middle cabinet of the dresser, what's located in that middle cabinet?
A lot of things. I have a lot of things in the dresser, so I don't remember.
Sure. Can you recall some of the things that are in that middle cabinet?
The women's stuff, I like my stuff that I used to do with my lashes, probably my waistband. And sometimes we have my gun case in there, so if they didn't find it under the desk, it would be in there.
How many magazines do you have for your firearm? Can you describe what those look like?
This is a long, it's like longer than the regular. One is longer than the regular, and then one is regular.
Okay. And then you have, so you have three altogether then, one in the gun and then two longer
Okay.
ones? Okay. How many of those were loaded when you left for work that day?
One.
Okay, so the two longer ones were not loaded? Okay. Do you recall the last time you used those two longer ones? Or if you've ever used them, I should say.
No, I don't use them.
You've never
I have
used them?
Yeah, I never used. I never
Okay.
even fired that gun.
You never tried that gun before? Okay, fair. So the two longer ones you bought just in case you might need them for later?
Mhm.
Okay.
So yes.
Yes.
Sorry, thank you. When you purchased them, you purchased ammunition separately?
No, I purchased ammunition with the guns.
Sure, but I guess my question is, the gun wasn't loaded when you purchased it.
Oh, no.
The ammunition was separate. The magazines were separate than the ammunition.
Oh, well, I had one that came with the gun, and then one I bought.
So we've got three magazines, right? We've got I'll call a normal magazine for the handgun that comes with the gun on standard, right?
Yes.
That magazine, was that loaded when you purchased it?
No.
Okay. The two extended magazines, the longer magazines, you purchased those after you purchased the firearm or at the same time?
At the same time.
Okay. And were those loaded when you purchased them?
No.
And then you purchased a box or two of ammunition, is that accurate? Okay. And you've never used the extended magazines, the longer magazines?
No, I never used the gun at all.
I will give me one moment to find that. No problem.
There's Mr. Franklin.
So this ethics thing? Is it?
Okay, Ms. Lee, I'm going to play this call from February 24th of 2025. Mr. Alexander placed to you about 10 p.m. and 47 seconds what this is. Remember talking to Mr. Alexander that night? And I think he went to jail after circuit court.
I thought there was a lot of times, so I'm sure that did the time.
You dispute that it was that day that he went to jail after circuit court. You dispute that that was that date at all?
No, sure.
Ma'am, do you recognize the voices that we're hearing?
Yes.
Is that your voice?
Mhm.
Is that a yes?
Yes.
We just heard a male voice. Is that Mr. Alexander's voice?
Yeah.
Okay. I'm going to start this recording as far as the conversation piece that we're talking about right now. And 12 minutes and 33 seconds in.
No, I don't. That's just where I have to reside. I don't have a stairs line or no curfew. I can go to the fuck up. This call will be terminated in 2 minutes. She said you had to reside. Why do you think she said I'm not putting a curfew? She would put a curfew and that's one thing. But no. That's just where my living residence, my living address has to stay. Wow. Yeah, that weak ass prosecutor was also bad.
Ms. Lee, did that refresh your memory that Mr. Alexander told you that he could live at your
I
house?
did not say live. I didn't hear that part in there.
That he just had
Yeah, and I would
his mailing?
object. I believe she's mischaracterizing the statements from Mr. Alexander. In the phone call that Mr. Alexander said, I can go wherever I want, where he doesn't necessarily state that I'm going to reside at your residence.
Yeah, I didn't hear no word him saying he can live there. in
Okay,
my
that's
house.
it.
Oh.
Which what I actually think was said was, Ms. Lee said, you can't come home. That sucks. I packed your bags and you go to your mom's. And he said, I don't have to go there. It is my living residence, my mailing address. I can do whatever the fuck I want. I can go wherever I want. That's why I don't have a curfew.
I think that's accurate recitation. of what you
Yes,
said.
that,
Okay, you can restate your question, objections overruled.
Lee, isn't it true that Mr. Alexander told you that he did not have to live at his mom's, it just had to be his mailing address?
I didn't hear him live at his mom's house. Yeah, I keep hearing that he said he had to reside at his mom. Yeah, she did say that.
For the voices that we heard on this call, you're not disputing are yourself
No, I'm not.
or Mr. Alexander. So the call speaks for itself.
Okay, no, but in the call, you reference your home as his home, correct?
Well, I'm his girlfriend, so.
That's not, like, that wasn't my question. In the call, you reference your home as his home?
Yes, ma'am.
Thank you. Okay, any redirect of your witness?
Ms. Lee, you never denied that Mr. Alexander stays at your residence on occasion, correct?
No.
And you recall in hearing that phone call that essentially you were telling him that he wasn't going to be staying at your residence, correct?
Correct.
Because you have essentially control over who goes and who stays at your residence.
Correct.
No further questions, Your Honor.
May this witness be excused?
Yes, Your Honor.
Okay, thank you, ma'am. You can be excused. Okay, any other witnesses? Yes, okay, and the prosecution's not intending to call additional witnesses, correct?
No, Your Honor, we're not.
Okay, you can proceed to argument.
Thank you, Your Honor. Your Honor, we're here today on 4 counts, one being,
You can have a seat. They're not calling anyone's.
one being a possession of a firearm by a prohibited person, one being possession of ammunition by a prohibited person, 2 counts of felony firearm. Based on the testimony today, Your Honor, it's not disputed that Mr. Alexander, based on the exhibit that has been admitted in People's Exhibit 1, does have a prior specified felony conviction on its record, therefore prohibiting him from purchasing and possessing a firearm or ammunition. As far as the testimony goes today, Your Honor, we heard from Officer Hutchings that during a search warrant execution, what was located inside the home in a dresser that both contained female clothing and male clothing, but in a drawer that had just female clothing was a firearm that was loaded without one in the chamber, that there was 2 extended magazines located in the middle portion of the dresser. One of those extended magazines was loaded, one was not, and that there was residency paperwork for, I believe Officer Hutchings testified for consumer's bill and the name of DeShaun Alexander for the 3211 Jerry Street address. Officer Hutchings also overheard Mr. Alexander telling the officer interviewing him that the gun was quote unquote his girl's gun, meaning he knew that the gun was there, he was aware it was there. The drawer that it was in was not locked in any way, it was completely accessible to Mr. Alexander, and he had knowledge of, therefore knowledge of and access to would equal constructive possession in this case. Further, Your Honor, from the testimony from Ms. Lee, which respectfully, I believe the majority of her testimony is largely not credible, considering that she is testifying that she didn't hear what we all heard on the jail call. Your Honor, Ms. Lee told this court that when she purchased those extended magazines, neither one of those extended magazines were loaded, that she'd never used them before, and that she purchased ammunition separately. She also testified that there was this gun case that was supposedly in the room as well, but we heard from Officer Hutchings that no other firearms related material was located throughout that search warrant execution. Based on those discrepancies, with addition to the jail call in which Mr. Alexander admits that he's staying there, that's our house, he's going to go back to his house, he doesn't have to live at his mother's house, he's acknowledging it's his house, and the fact that we actually have 2 utilities within his name in this home, both consumers and board water and light, we ask the court to bind this over on the charges of complaint.
Thank you, Your Honor. Your Honor, I believe that the evidence has shown that there was not probable cause of Mr. Alexander having any type of constructive possession over either the firearm or the ammunition in this place. Ms. Lee testified that she purchased the gun herself. She testified that she maintained that she had bought ammunition for the gun. She testified she bought the magazines for the gun. She testified that she typically kept it in a gun safe. While the officers did not necessarily find that, that doesn't mean it wasn't there. I mean, they did not, there's a ton of items scattered about a house. I don't know if it was in some other drawer or where it was. But either way, she testified that, she typically would always have it with her, whether it be in her car or on her person at work. When she's at work, she'd have to leave it in the car or put it in her locker. And she testified on this occasion, it got left behind due to her nails appointment. running late and her work calling her to go in early, and therefore she didn't have time to stop back at the residence. She testified why Mr. Alexander was at the residence on that occasion to let her dog out. I don't believe we heard we did not hear any testimony about, when Mr. Alexander got to the residence versus when the police came in, because I don't believe Officer Hutchins was one of the first people in. She further testified that, yes, she did have a couple bills in his name. That was because she fell behind in payments and owed too much money and was going to get her power turned off. So she had a new person or open an account on her address. She is the only person, she testified she's the only person on the lease. She controls who stays there. Again, she doesn't deny that Mr. Alexander does stay there on occasion. However, she did testify his primary residence is with his mother. So I would ask the court to deny bind over on all 4 counts because the lack of constructive possession of either of the firearm or the ammunition essentially kills off all 4 counts in this matter, Your Honor. Thank you.
Thank you. Taking time for preliminary examination was for today, and the witnesses have been heard. The purpose of the preliminary examination, Mr. Alexander, is for the people to put forth sufficient probable cause that the felonies that you're being charged with were actually committed, and then that you that there's probable cause that you're the person who committed those felonies. So this is not a trial. They don't have to prove each element beyond a reasonable doubt. It's just more than mere suspicion that the crimes alleged have occurred. And then the court will be the determiner of any credibility issues. The court can weigh the people's likelihood of success at trial. And then we look at, it's a flexible burden as to, flexible as to the evidence and how it's submitted. It could be based on circumstantial evidence or direct evidence. But if there is a question of fact that stems out of the evidence, then that means that the matter must continue to trial. And so we have here in your complaint, count 1, weapons, firearms possession by a prohibited person, count 2, weapons, ammunition possession by prohibited person, and then there are 2 accompanying counts of felony firearm, count 1 and count 2 charged under specified felony. And so to prove that at trial, the people would need to prove that the defendant knowingly possessed, used, sold, distributed, received, carried, or shipped, transported, or purchased a firearm and or ammunition in this state. Second, that at the time the defendant had previously been convicted of a specified felony. And in this case, the allegations that he was previously convicted of home invasion 3rd degree, the court does have a certified judgment of sentence. And the next element that people would need to prove is that either less than 5 years had passed or that the defendant's right to possess or use, sell, receive a firearm had not been restored pursuant to Michigan law. So we had testimony first from Officer Melinda Hutchins from Lansing Police Department Special Operations Unit. She testified that on the date in question, February 6, 2025, that she was present at the address of 3211 Jerry Street. That's in the city of Lansing, Ingham County, state of Michigan, which makes venue in this court appropriate. That she reported after a search to assist with searching the residence, and that she searched the area of the home in the bedroom. I think she described it being more than one bedroom, but there was one bedroom that actually had a bed in it. That she searched a drawer, dresser, drawers, and that she described that dresser to be longer, that there were multiple drawers, that there were both men and women's clothing found in that bedroom, and that there was mail located in that bedroom, with some mail with the female's name, some mail with the male with the defendant's name. She, at the time, I believe, had to be refreshed as to the name of the female located on the mail. That the firearm was located along with ammunition, that it was located in the left side of the dresser, which was in the middle drawer, and then with another box of ammunition located She stated that that drawer that the firearm was located contained women's clothing. And that during the search, she overheard the defendant say that the gun was his girl's, meaning the gun belonged to his girlfriend. But that the defendant did not appear to be surprised that there was a firearm in the home, and that there was also a bill, I believe, consumers and or board of water and light bill, that the witness was not clear at the time which energy bill it was, but that it stated the defendant's name on it with the jury or Jerry address listed on there. We had testimony today from the defense witness as New Lee, who identifies as a girlfriend to the defendant, Mr. DeShaun Alexander. She states that she resides at the address of 3211 Jerry Street, and that she's the only person that resides there, that the defendant doesn't live there, but that they're in a relationship. They've been in a relationship for a couple of years. He stays there often, and that, of course, he probably has things there, but he does not access her home without her permission, unless she sends him there for some purpose. And she discussed sending him there from time to time relative to helping with her dog, or something to that effect. However, on the date of February 6th, she was not home at the time that the police were there to execute a search. The defendant was there. I think the first witness testified that when they arrived, the defendant was present when she arrived, the defendant at least was in the living room near the window. And the witness, Ms. Lee, also testified that there were some utilities in the defendant's name, and that's because she was behind on some bills, and she needed her boyfriend to provide some assistance. She testified that he's not on the lease. There was also a cross-examination questioning about whether or not Ms. Lee and Mr. Alexander had conversation by way of a jail call discussing residency and whether or not Ms. Lee's home is Mr. Alexander's home. I believe that that's a question that's yet to be flushed out. It's probable that Ms. Lee's home is his home. People in dating relationships often give free rein and access to their significant others. You can have a key. You can leave things here because you're probably spending the night, and you're not on the lease and you don't live there, and I have exclusive control. However, it's not typical that people in dating relationships have utility bills and the person who's not living there's name. That's not typical, because that's actually fraud. So if that is something that's happening, then it gives credence or credit to the fact that it's more likely than not that he probably is living there if these bills are in his name, not one, but two bills. There's multiple clothing items also located there. And then he seems to be completely unfazed by the finding of a firearm located in a bedroom that seemingly has mail with his name on it for that address, and some male clothing items. So based on that, the court is satisfied that there's sufficient probable cause to proceed to trial. So this matter will be bound over to the circuit court for further prosecution. The bind over date is going to be March 2nd. That's the date the circuit court gets the file from the district court. Mr. Alexander does not need to appear in the circuit court on the 12th. March 12th, is that what I said? You said second. I'm sorry, March 12th. Okay, so your next court date, Mr. Alexander, will be a pre-trial in the circuit court. Your attorney will be made aware of what that date is, okay? Okay, and the address that we have for you is on Conrad Ave. That's still an accurate address?
Yes.
Okay. Bond was set at 30,000 cash shorty with GPS tether and scram tether.
Your Honor, we did want to address the scram tether specifically.
Please do.
Yes, obviously, it's important for the court to know where Mr. Alexander is. That's why the GPS tether makes sense, but this is a gun case. Alcohol was not part of the issue here, or there was no evidence that he was on drugs at any point when the police were dealing with him. So I would ask that the scram tether requirement be removed and that the rest of it remain intact.
Counsel, did you understand?
Thank you, Your Honor. I think it's important to note that Mr. Alexander's criminal history does not have any sort of alcohol-related convictions to it. I'm not quite sure. Just because there's a prior substance abuse pending file, if that's why the magistrate chose the scram tether, I'm unclear, since scram wouldn't test for that anyway, so I would have no objection to removing the scram tether.
All right, the scram tether will be removed.
I would ask the court to remind Mr. Alexander, just to avoid any future confusion or any potential future bond violations, that 801 Conrad is the residence that he is supposed to be living at. That is not a mailing address. He's supposed to be living at that address, staying there at night, he's not supposed to be staying at other homes. That's the purpose of having the GPS tether and address that it's tethered to.
Well, I would hope that his counsel is also advising him, and that seems to be his complete and utter defense, is that he doesn't live at Drury Street. So if the tether and other documents and evidence show that you actually do live at the Jerry Street address, that wouldn't be favorable to your defense. So I'll remind you that you're supposed to be living at Conrad Avenue. Doesn't mean you have to live there. You can live wherever else you want to live, other than it wouldn't be advised that you live at the location of the incident, because that's the defense that you're using, that you didn't live there. Okay, do you have any questions about that? No. Okay, bond will continue otherwise without the scram tether. I'm gonna return your exhibit and you're all set.
Thank you, Your Honor.
Thank you. Oh, you can turn your thing back on. I just had you turn it off because I couldn't hear that video. Mr. Palmer, I think your client is here now.
Yes, Judge, he's here and present in the courtroom. We're ready to go whenever.
Okay. Are we having an exam on that?
Yes. It sounds like Mr. Nagel's officer exam.
Yes. I have two witnesses.
Okay, I'm gonna wait for me to handle blacksmith first.
Sure.
Your Honor, if Mr. Swartz happens to come back in, we'd be ready to go on with I don't have a victim here on that. I don't have a victim here on that, so I think that we're just gonna let that be a motion from the defense.
State of Michigan versus Ahmad Whitby 25-00250. Parents, please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. I'm Jacob Starks, the Fourth Assistant Public Defender, here on behalf of Mr. Whitby. My apologies, Your Honor, for the running back and forth this morning.
You're fine. No worries. Okay, Mr. Whitby is scheduled for a preliminary examination today on assault with intent to murder. And my understanding is we do not have the necessary witness, correct?
That's correct, but just for the point of clarification, this was a assault GBH, so less than a murder. MDB, the necessary witness is not present, Your Honor. Therefore, I expect the people are unable to proceed, and I expect a motion from the defense.
Thank you, Your Honor. As the defense moves to dismiss at this time, Mr. Whitby understands that if Your Honor grants this request to be dismissed without prejudice, defense is prepared and able to proceed this morning, and respectfully, if the people are unable to proceed, defense requests to move to dismiss. Thank you.
Thank you. Mr. Whitby, do you have any questions about what your attorney just said? Okay, we'll get you a copy of dismissal in just a moment. You're all set.
Yeah, the reader. Yeah.
Thank you.
Of the state of Michigan versus Regina Blackman 24-03446.
Just a. Waiver, anybody can stand in.
Your Honor, may it please the court, Melinda Boxia, T 76176 on behalf of the Ingham County Prosecutor's Office.
Thank you. Well, we've got 4 prosecutors now.
Sorry, Matt Nagel for the people.
Okay,
Aaron Robinson, Assistant Public Defender for Ms. Blacksmith, who's standing to my right.
thank you. Today was the date scheduled for preliminary examination on police officer assault and counsel assault and battery. How are we proceeding on that?
This will be a waiver.
Is there an offer at all?
There is no offer at this point, Your Honor, but negotiations will continue.
Legal counsel. Mr. Nagel.
Oh, thank you.
And first judge.
Thank you.
Yep, so stand up.
Okay, let's see, Ms. Blacksmith. You tired?
No, I'm trying to let her go.
Oh, okay. Do you understand that you have the right to have a preliminary examination in this matter?
Yes, Your Honor.
You understand the purpose is to require the prosecution put forth evidence to establish probable cause sufficient that a felony was committed and insufficient probable cause to charge you as the person who committed the felony.
Yes, Your Honor.
You want to unconditionally waive your examination? Is anyone threatening you to do that? Any promises being made to you if you waive your exam? And you understand that once this matter is bound over to the circuit court, you can't later decide that you can have your exam if you don't like your offer or something. You understand that? I find your waiver to be freely and voluntarily given. Your bind over date's March 12th. That's the date the circuit court will get the file from the district court. It's not a date that you need to appear in circuit court unless your attorney is making a motion for you to be arraigned at circuit court, okay? Do you have any questions at this time for the court? She's being held on some other matter at Eaton County.
That's correct.
Bond at 3,010% will continue as well as the no contact order. Any additional matters for the record?
No, Your Honor.
No, Your Honor, thank you.
Thank you, you're all set. No contact order. She wants to know who her no contact order is with? Yes. It's a Michael Calendar and Jamie Aker. Yep. Let's see, we're about to start whose exam?
Your Honor, may I approach?
Mr. Roger Jameson, I believe.
Spiker's on one, I'm on the other.
Oh, wonderful.
Sure.
Okay, let's see, on the record in the matter, the people of the state of Michigan versus Shakir Rogers Jameson, 25-00-381, council appearance.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Rogers Jameson, the gentleman who's standing to my right.
Okay, today was the date set for preliminary examination. Assault was intended to create bodily harm. How are we proceeding on it?
Your Honor, it's my understanding, well, first I should say that an offer has been extended in this matter for defendant to plead guilty to aggravated domestic violence. And then the balance of the charges would be dropped. It's my understanding that the defendant has chosen to decline that offer and wishes to proceed with the preliminary exam. The people are prepared to continue with the preliminary exam this morning.
Okay, and obviously the offer expires at the beginning of the exam.
That's correct, yes, ma'am.
Okay, and you understand that offer, sir?
Yes, sir.
You don't want to accept it?
No, Your Honor.
Okay. Any other preliminary matters?
Only with respect to what appears to be an allegation of a bond violation that I just found out about and brought to the court's attention before going on the record.
Sounds good. Any other preliminary matters?
I don't have any other preliminary matters at the moment, Your Honor, other than could I just have a quick second, since I just also learned about this
Absolutely.
alleged bond violation, could I just talk to the client about it real
Yes.
quick, explain what's happened?
We can go off the record.
Thank you.
You said this morning? You're saying this morning.
Can you send
That
that?
is
not true. Say-
Hold on. Don't say
You can
anything
send
out
to
loud.
everybody, please.
All right. Say anything out
That'd be
loud.
great.
Could we just go in the hall very quickly?
Sounds good.
Watch your mouth.
Have a seat.
Okay, keep it forever. So Rogers, I'm gonna ask you to keep quiet, okay? Don't want to make it worse on you. Do you need black suits?
Sure, I don't.
Something except for about it.
You got it, Kristen. Well, he's out of parole, so he's got an MDOC hold, I think. What's he accused of?
So. What's that? Yeah, that's bad.
Yeah. We're coming back.
Yeah, I've seen.
Okay, all right.
The victim was free and it's Steve and everything.
Steve. Oh, they love each other too.
Yeah.
It's literally good.
Yeah.
What's going on? 3 minutes.
Oh, that's.
Look, I get along with them.
Yeah, I would agree with that.
Except me.
So Jane Packman, you see that? So did I, you know, so this white is. Hold on, man, just stop talking. Yeah, just camera, wife and dog all died in New Mexico. Weird. But then the news said that foul play is not. Thank you, maybe it's suicide or something. Or like there was some sort of gas leak in the house.
Oh, yeah, you're talking about Gene Hackman? It sounds like a carbon monoxide thing, I'm thinking, something like that.
Crazy.
I thought the original report I saw said they weren't not treating it as suspicious death, but now it's under investigation, which I would assume is probably something to do with the gas leak.
Right.
No, he was a Marine.
We do, yeah. He was also, what was it, Dustin Hoffman?
Until yesterday,
Something.
yeah. Yeah, they were.
Yeah.
I know they're the same era, but I didn't
Right.
realize that they were roommates. That's sad, that one hit me yesterday. He's a little older than I thought he was, but he was like,
That was 9, right? 95.
I just watched not too long ago, Uncommon Memory 2. If you,
Really good?
highly recommend, Gene Hackman, highly recommend look it up. If you've never seen it.
Okay. I've seen a lot of it.
It's a young Patrick Swayze.
Oh, really?
Yeah.
Trying to stay out.
I know, man, that's no thing. We're going to have an argument. I understand. Okay, I get it. You gotta let me just do my work, all right? I understand it's frustrating, but you gotta let it work, all right?
So.
Me? You're saying I'm sorry? I'm the system. I'm part of the.
All right. Back on the record. You can be-
That's my only recommendation.
How many witnesses are there?
I have 2, but I may just ask for bind over after the first witness round.
Okay, sounds good. Sequestration is granted.
Yes, Your Honor.
Okay, you can call the witness.
Thank you, Your Honor. The people call Officer Kimberly Jackson.
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
State your first and last name and spell both.
Kimberly Jackson, Kimberly, Jackson.
You can proceed.
Good morning, Officer Jackson. With whom are you currently?
The Lansing Police Department,
And how long have you been employed with Lansing Police Department?
over 3 years.
What are your current responsibilities with Lansing Police Department?
I am a road patrol officer.
And what are some of the duties that you perform as a road patrol officer?
I respond to calls for service to 911.
And were you working in this capacity on February 7th of this year?
I was.
And do you recall being dispatched to your location at 900 Long Boulevard in Lansing, Michigan?
I was.
Is that County of Hingham?
Correct.
Can you tell the court what you remember about the purpose of that dispatch?
The original call came in as a domestic assault between a male and female. On my arrival, I noted that there was a white female standing at the south side of the building that the service was put in for. She gestured to me several times to come to her. I ordered her to me. After several minutes of me ordering her to me, she eventually started walking toward me. She kept looking over her left shoulder at an upper balcony for a unit. When she got to me, she identified herself as Stolly, the victim, and that she had been assaulted by her significant other, Roger Jameson, who was still currently in the apartment, and that's why she was looking over the shoulder.
Okay. Did you know Miss Stolly? From prior contact?
Yes, I've had prior contact with Miss Stolly.
And did you know the accused, Mr. Shakir Roger Jameson?
I did. I've also had prior contact with him as well.
What is your understanding of the relationship between Miss Stolly and Mr. Roger Jameson?
They have been on-off dating for a period of time. They have one child together that the state of Michigan is in custody of, and then she is currently pregnant with his child.
Okay. So they had a current or past relationship with a child in common at the time that you saw Miss Stolly on February 7th, is that correct?
Correct.
And did she indicate that Mr. Roger Jameson was still in the building when you were speaking to her?
She did. She said he was in the upper unit. So.
Did she give you a statement regarding some form of an assault that had taken place?
Yep. She stated that she had been physically assaulted by Mr. Rogers over a period of time over the prior night. Are you asking me to go into detail about the assault?
Can you, yes, please, can you tell the court about what happened in the assault that she described?
She stated sometime the night before he had he as in Mr. Jameson had contacted her saying that he had nowhere to go and that he was homeless and he wanted to spend the night. Miss Stolly is in a housing program where she's not supposed to have people over, but after the negotiation with him, she invited him over. While he was there, he made the point of bringing up their relationship, that he wanted to get back together with her. She was uninterested in this, and he spent time, she described as putting hands on her.
Did she describe where the hands were when she said hands on her?
Not in that initial statement. The secondary statement she said is when that first argument occurred. After it occurred, she had gone to the bedroom and laid down the bed where he had jumped on top of her and placed his hands around her neck.
Okay. And when she told you that the hands were around her neck, did she indicate whether or not her ability to breathe was affected in any way?
Correct. She said that she could not breathe while he had his hands placed around her.
Did she indicate any kind of timeline for like how long this would have occurred?
I don't recall. She didn't lose consciousness or describe losing consciousness or anything like that.
Okay, fair enough. When you were speaking to Miss Stolly, did you notice any bruises or marks or anything of interest on her?
She had the bruise marks on her arm resembling a white mark.
Okay. And did she give you a statement about that?
She did. She stated that she had been bit on the arm by him and that she wasn't allowed to tell anybody about it because she would lose her housing. She was caught with him.
And did she give you any further statements about anything else regarding an assault that night?
She stated at some point he took her cell phone and struck her with it in the shoulder. She did not have any bruising that I noted from that prior assault.
Fair enough. I think you indicated earlier that Mr. Rogers Jameson was still in the building when she was giving the statement. Did you happen to see Mr. Rogers Jameson that night?
I did.
Would you recognize him if you saw him again?
I would.
Do you see him in court today?
I do.
Can you point to him and identify an article of clothing that he was wearing?
He is wearing a ripped jean jacket and sitting next to the fence.
Thank you, Your Honor. And thank you. Thank you. Your Honor, did the record reflect that, please?
Any objections or identification?
No objection to today's exam, just thank you.
Identification's noted.
Can you tell the court the circumstance in which you saw the defendant that night?
I was provided a key to the unit by Ms. Stolly. And advised that he's still in there. I had suggested when additional officers arrived on scene that there was a west and an east entrance to the building. Those two officers went to the west side entrance to prevent him from running out. I entered the building, the unit door was still closed. I noticed those officers were not in the building yet, so I stepped through the breezeway door at the center of the building. As I opened that door to gesture officers to come to the unit, I heard the door to unit 822 open. So I turned around and observed Mr. Rogers exiting that unit.
When you saw him, what did you do?
I advised him not to run, not to go back into the apartment, and that he was being detained for the purpose of an investigation.
Was he cooperative with you at that point?
Yes, he was cooperative.
And then what did you do with him next?
I detained him in handcuffs and advised him that we were going to go down to my car to collect a statement. All right, guys.
Okay. And did you take a statement from the defendant?
No, I did not.
Just a couple more questions about the statement that Ms. Stolly gave you. When she was telling you about what happened with the bite mark and with the hands on her throat, did she give any indication that this was a mutual fight between the two of them?
She did not advise fighting back while they were fighting.
Okay. Did she indicate in any way that his putting hands on her was an accident by any means?
No.
I think no further questions at this time.
Thank you. Morning, officer.
Morning.
Just a couple of questions. You indicated that you were dispatched, I guess as a result of a 911 call, is that right?
Correct.
And so when you appeared, Ms. Stolly was already outside of the building, correct?
Yes, sir.
And she was at first hesitant, you indicated she was at first hesitant to come over and talk to you, is that right?
That's right.
And eventually she did that after, I don't know, I'm not trying to put words in your mouth, after some coaxing from you. Does that sound fair?
Correct.
And I guess to be fair, you didn't witness an actual assault between Ms. Stolly and my client, correct?
No, sir.
All right. So your knowledge of this is based on what Ms. Stolly told you. Is that fair?
Yes.
All right. Now you indicated that apparently there was some, based on your conversation with Ms. Stolly, there was some assault that took place, and that included Mr. Rogers putting his hands around her neck. Is that right?
Correct.
All right. Did you see any markings on Ms. Stolly's neck that would indicate that to be true, or is it based just on her statement to you?
It's based on her statement. She did not exhibit any of those.
Okay. You indicated that during your direct examination that you saw a bite mark on her arm, right?
Yes.
And she told you that bite mark was a result of something that Mr. Jameson did to her, correct?
Correct.
Again, you didn't see that, right?
I did not see that.
All right. Did you see any other marks on Ms. Stolly that you did not place into your report?
No.
And you indicated that, at least from Ms. Stolly's perspective, this incident started or at least part of the argument was, or part of the problem, I suppose, is that Mr. Jameson was not supposed to be at Ms. Stolly's apartment because her housing situation, whatever it may be, prevents him from being there. Is that right?
The argument started from him bringing up their relationship, which she did not want to address.
Okay, but okay, that's fair. I'm not trying to, I wasn't supposed to be a trick question. You indicated that there was some issue about Ms. Stolly told you that Mr. Jameson was not supposed to be at that apartment, or she was subject potentially to losing the apartment in some way.
Ms. Sully told me that Jameson had said that to her, not directly to me. I don't know if there's any effect on him being in that apartment at all.
Gotcha. All right. I have no further questions of witness, Your Honor. Thank you.
Redirect.
None, Your Honor.
Thank you, officer. You may be excused.
I think we're going to miss it here. The people have no further witnesses.
Any defense for witnesses today?
Not today, Your Honor. Thank you.
Each argument.
Thank you, Your Honor. Just briefly, the people obviously will be requesting that this be found over as charged. Count 2 would be the accompanying misdemeanor domestic violence. People are asking that count 1, the felony assault with intent to do great bodily harm less than murder or by strangulation bound over as charged. People have burden of showing probable cause. First, that the defendant committed a battery on Miss Deanna Stolley. In this case, the testimony offered by Officer Jackson is that the victim in this matter gave a statement that she did receive a battery from the defendant, in that the defendant put his hands around her neck and squeezed, as well as received a bite mark from the defendant following an argument. Second, that the touching must have been intended by the defendant, that is not accidental, and it must have been against Ms. Stolley's will. In this case, the officer testified that the witness at least gave no indication that this was a mutual fight, and also did not indicate that she believed that the contact from the defendant was an accident. And third, that the battery was committed by strangulation or suffocation. In this case, the statement was that the defendant did strangle the complainant. The complainant did not offer a timeline as to how long it would have occurred, but she did indicate that she had trouble breathing while her neck was being squeezed, although she did not lose consciousness or anything of that matter. Based on the testimony, Your Honor, people would ask that probable cause be shown, that the people can move forward and bind over on count 1 and 2. Thank you.
Mr. Farmer?
Thank you, Your Honor. Obviously, I'm asking that the matter be dismissed for lack of probable cause. I certainly absolutely recognize that it's a low burden at the preliminary examination. My testimony today would be, or my request today would be that the court take into account, first, obviously, Ms. Stolley did not appear today. The only witness that we've heard testimony from was this officer, Officer Jackson. She obviously testified that she did not witness the incident. She only took Ms. Stolley's statement. She further indicated that there was, at least with regards to the assault strangulation count, the felony count, that there was no corroborating evidence. It was simply Ms. Stolley saying, he choked me for this unknown amount of time. Apparently she's claiming that there was, she had difficulty breathing. Obviously, Ms. Stolley has not appeared today to testify, to tell the court or the parties her perspective. Officer Jackson testified that there's no corroborating evidence. There were no marks, scratches, wounds, bruising, anything of the sort to corroborate Ms. Stolley's story. Notably, she did see a bite mark, and Officer Jackson testified to that, but that bite mark, it appears, would go to count 2, the misdemeanor matter, not count 1. I would submit to the court that there's not enough evidence here. I would ask the court to dismiss at least count 1 for lack of probable cause, set count 2 under the misdemeanor docket as it's a misdemeanor. Thank you.
Okay, three states up for preliminary examination. The burden is more than mere suspicion that the crimes alleged occurred. So it's just probable cause standard. This is not beyond a reasonable doubt. I don't have to prove each element at a very high burden. And so the burden is relatively flexible and it's based on facts and circumstances presented at the time of today's examination. We have the testimony today from one officer, that's Officer Kimberly Jackson from the Lansing Police Department. She says she's been employed there for 3 years and she's currently on road patrol. And at the date and time of February 7, 2025, she reported to the area at or near 900 Long Boulevard in the city of Lansing, Ingham County, state of Michigan, which makes venue in this court appropriate that the original dispatch was for a domestic dispute. that when she arrived, she encountered a subject that gestured to her, and that subject appeared to be looking over her shoulder, that she approached and spoke with that individual. She identified that person by name, last name, I assume Stolly is the name she used, and then identified that person as the victim, stated that she had prior contacts with Ms. Stolly, and she was familiar also with the defendant that she identified in the court today as Shakir Rogers Jameson. She stated that the victim or alleged victim reported an incident having occurred involving an assault, and that it was an event that occurred maybe over the night, and that the defendant was still currently inside of the building, which is why the victim appeared to be looking over her shoulder. She said that she is pregnant with the defendant's child, that she's in some residential housing program, which does not allow her to have visitors, that the defendant arrived or contacted her and arrived to that area, indicating he was homeless, he had nowhere to go, and that she allowed him into her residential space, that while inside the space that he brought up their relationship and discussion of them getting back together. She didn't want to address it. That started an argument. She went to lay down. The defendant jumped on top of her and placed his hands around her neck. And she reported, at least to the officer, that it inhibited her ability to breathe. The amount of time that the hands were placed around her neck is unknown, but I don't think that's an actual element of the amount of time as to the crime. And then she testified that he bit her on her arm. The officer did note that there was a bite mark. It should also be noted that this is a report of an incident having have occurred maybe the night before. So whether or not there would be evidence to corroborate someone placing their hand around your neck, I'm not clear. I don't know the skin color of the alleged victim and whether or not she had, or someone that would bruise easily, or how much actual time had passed from the time of the alleged strangulation to the time that she's talking to the officer. Are we talking 1 hour? Are we talking 3 hours? I don't know. And she being Ms. Stolly, expressed some concern to the officer about making a report due to the fact that she was not supposed to have the defendant in her residential housing. The officer reported that she was inside the area in the building of 900 Long Boulevard when she heard the door to unit 822 open, which was the victim's unit, and saw the defendant open the door and exit. She told him not to run and that he was being detained and taken into custody. Obviously, this evidence being admissible by way of hearsay under 768.27C. And so to prove an assault by strangulation at trial, the people would have to prove beyond a reasonable doubt first the defendant committed a battery upon Ms. Staley. A battery would be a forceful, violent, or offensive touching of another person or something closely connected with another person. Second, that the touching must have been intended by the defendant, that is not accidental, and it must have been against Ms. Staley's will. It doesn't matter whether the injury caused or whether the touching caused an injury. So the fact that there's no corroborating evidence is noted here. It's not really required. The battery was third, that the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of blood flow or breathing by applying pressure on the throat or neck or by blocking the nose or mouth. Based on the testimony evidence here, the court is satisfied that there's sufficient probable cause as to count one, that the victim, Ms. Stolly, testified that when she laid on the bed, the defendant jumped on top of her, placed his arms around her neck, and inhibited her ability to breathe. That satisfies the elements. And so that will be bound over to the circuit court for a bind over date of March 12th. Count 2, being domestic violence, will accompany count 1 and its charges an habitual offender second offense notice. We also have the issue of a recent notification to the prosecution's office. I'm not sure if that was forwarded to the court yet.
I did forward a copy to the court. I did not include your honor, but I can send it again.
Well, my staff should report. Thank you. Oh. Okay, and so the court, as of this morning, I should say, the prosecution's office, as of this morning, received an alert which was later forwarded to Mr. Rogers Jameson's attorney as well as the court. And this is from a Ingham County Health Department. They provided information alleging that it was reported that during parenting time earlier this week that Mr. Rogers Jameson made contact with the victim and the two began arguing about being together. And it was the understanding of the Department of Health and Human Services that there is a no contact order that is in place for the protection of the victim. And so that would be a violation of your bond condition. And so you have the right to have a contested hearing on the bond condition. You have the right to be represented by your attorney at the time of that hearing. If you're found to be in violation of your bond can be revoked. You could be sentenced to a term of jail time for contempt of court, 93 days in jail for a violation. Do you understand that? And you do have a GPS tether, correct?
Yes, Your Honor.
Counsel, how do you want to proceed?
Well, Your Honor, I guess I would ask a couple of questions of the court first. That being the following. First of all, obviously all of us, the prosecution, the court, and I all became aware of this matter just this morning. So presumably there are not witnesses here to testify. One of the issues I have with, as indicated by the email, we're sort of working with hearsay within hearsay here in that worker Jack is the one who reported this, but it sounds based on the email that Miss Jack is not even the one who witnessed the contact. It was someone else that witnessed the alleged contact, reported to Miss Jack. Miss Jack then relayed that to the prosecutor's office. So now we're working within a couple of matters of hearsay. I guess the other thing is, certainly in talking to my client, I know my client strongly denies that he violated his bond conditions. He would like a hearing on the matter. But I guess the other question becomes if the court certainly welcome to correct me if I'm wrong, but my understanding is that if the court is going to bind the matter over today, then the court, once the court does that, it loses jurisdiction over the bond violation. The bond violation then becomes the problem of the circuit court. So I guess the first question would be, is the court's intention to hold the bind over so that we could address the bond violation on a different date? Or is the court's suggestion that the bond violation would tag along and be dealt with at the circuit court?
It would be nice to have this matter dealt with at the circuit court. However, our experience has been when there's a bond violation, the circuit court tells us it's our bond.
Sure.
So it becomes a confusion. And so again, in order to even move forward with this, the matter now becomes, are we going to get the victim here? When the victim didn't appear today, is the caseworker who reported it or the supervisor going to come? I don't understand how we're gonna move forward with that.
Right, well, so at this point, Your Honor, the prosecution knows what the court knows. There does appear to be another agent CC'd in that email that I received. It's the court's bond. If the court is interested in seeing this through, I would be more than happy to follow up with DHHS find out what it is in fact they've witnessed, what evidence I can present. I once again try to touch base with the victim to see if I can get her here, and then we can come back and address it at that time. However, if the court prefers to let this continue to the circuit court, people have no objection to it.
My preference is to let this continue to the circuit court, primarily because he is on GPS tether. I've not gotten any violations as it relates to the tether. And I agree with Mr. Palmer as to the nature of the complaint being hearsay within hearsay. And then the concern we have is we don't even have a victim here today. So even holding a hearing, let's say we have the actual foster care supervisor who reported this, that's still some hearsay that she surmised what their conversation would have been unless she was on the phone with them.
Right, and then we don't need to go down this rabbit hole today, but then we have the whole argument as to whether 27C even applies to that situation because it's not a law enforcement officer. I think things get really complicated at that point.
I think it would, but
I don't
think it would either. I'm just not trying to make a full argument.
I wasn't even thinking of that 2017. I'm just saying it's hearsay again. Just even bringing the person who reported it in,
Right.
Unless the victim's going to come and report this contact, we're tied on it.
Right, which is why I would have no objection if the court wants to continue the circuit court. I just felt it was my responsibility to bring to the court's attention at the very least.
It was. You did the right thing for the bare minimum of admonishing the defendant that he's not to have contact directly or indirectly with Ms. Daly. They do not to have phone calls, text messages, DMs, smoke signals, Morse code. No forms of communication. Do you understand that?
I understand.
Okay. Is that a problem for you?
No, it's not.
Okay. Again, I don't have any other violations. I too am familiar with Mr. Rogers Jameson. I've had other cases with him. He tends to come to court unless there's a health issue. And so I am happy to continue his bond at this time.
Thank you, Judge. I have nothing further.
Nothing from people.
Thank you. You're all set.
Thank you.
Okay. Thank you. Okay.
Catch your breath.
Okay, roger that. I think that does it for me for this morning.
Oh, you know.
Unless the court disagrees.
I said we keep Mr. Nagel for a while. Love the game.
Kenneth Wilson is me, and so is the Bill Jackson.
Okay. Thank you, sir.
I got you. One, he does. Hold on.
Okay.
Negative. That's all me. Good morning, Your Honor.
Good morning. How are you?
Yeah, it's still technically morning. Another 20
We
minutes.
got about 19 minutes.
Good day, Your Honor.
Have a good one.
Now the court is ready. We are ready on the Kenneth Wilson matters. It's going to be a waiver on both files.
Okay, what are we doing with Jackson?
Jackson, I believe, is also going to be a waiver based on my conversation with Mr. Etheridge, but I'd like to handle the Wilson waiver first in case Mr. Jackson changes his mind.
Well, I just asked because he has to be brought up.
Yeah.
We can bring him up. This is the people of the state of Michigan versus Kenneth Ray Wilson Jr. 25-00123 and I have 25-00420. Council appearance.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Wilson in both of these files.
this date scheduled for preliminary examinations on both files. And you said that there's going to be a waiver.
Yes, Your Honor, on both files.
Oh, was there an offer?
There was, Your Honor. The offer is for the defendant to plead guilty in file 25-420 FY to, I believe it was count 1, assault and resisting obstructing officers, as well as count 3, the DUI charge or OWI charge. And then in file 25-123, pleading guilty to the 2 assault charges, that being count 4 and 5. The intention is to resolve this matter at the circuit court, to seek to waive it up there.
That is correct.
Okay, Mr. Wilson, you understand you have the right in each file to have a preliminary examination on these matters as to each felony count?
Right.
You understand the purpose is to have the prosecution establish that they have sufficient probable cause that the felonies were committed and then sufficient probable cause to charge you as the person who committed the felony.
Yes.
Are you willing to unconditionally waive your examination in both files?
Right.
Anyone threatening you to do that?
No.
Any promises extended to you if you waive your exams?
No.
And number 2.
We have found your waiver to be freely and voluntarily made. Your bind over date in both files, March 12th. That's the date the circuit court gets the file from the district court. You do not need to appear in the circuit court on that date, okay? Your next court date will be a pretrial. Your attorney will be made aware of that date. Do you have any questions?
No, Your Honor.
Bond and file number ending in 420 is 3,000 personal recognizance. That will continue. Has your phone number or address changed since February 11th? Okay, bond and file number ending in 123 is 3,500, 10% with GPS tether and victim notification if possible. That will continue. Any additional matters for the record?
Not from the people, Your Honor.
No, Your Honor. Thank you.
You're all set. Thank you.
Thank you.
I got it.
Get my email, because you can always email.
Yeah.
Hardly found it.
Yeah. RATIADE at gmail.com. It's nothing else.
You know, stuff like that. All right. Sending now. Including my sensational signature. Did they give you any problem? Show that it was from my record.
Thank you.
You're welcome. Addie, if this does end up going, I will have exhibits for you.
Okay.
Judge just walked into the back. Judge, know where I need to go.
I'm just trying to see, because this is supposed to be a waiver.
Yeah.
I'm just trying to see if he's still doing it, so you guys gotta sign it.
You here for this case?
Just want to make sure we weren't here for something else and because of yeah. We have had that happen before, so I'm just waiting here for hours. I think we're ready.
Ready?
Strength.
Before the last meeting. That might be true. That would be good. Yeah, that music is. Maybe. Go back. That's something else. So once they see this, they can show.
All rise.
Seated. Okay. This is the state of Michigan versus Philip Jackson, 25-00447 FY. Appearance, please.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Morning, Your Honor. Attorney Derek Esposito, Public Defender on behalf of Mr. Jackson, who is in the courtroom seated to my right.
Okay, Mr. Jackson has a preliminary examination today for 2 counts. Start with intended to great bodily harm, that's a murder, thereby strangulation, and there's a domestic violence and a third offense notice, and an habitual offender notice. How are we proceeding on this?
Your Honor, there's going to be a waiver of the examination today.
Is there an offer?
There is not.
I'll step on that. Okay, Mr. Jackson, you can step up. Okay, Mr. Jackson, you understand the purpose of the preliminary examination? I can't hear you. Okay, so you have the right to have the prosecutor put forth evidence at your exam that establishes that they have sufficient probable cause that the felonies you're being charged with were committed, and the sufficient probable cause that you were the person who committed those felonies. You understand that? So you want to unconditionally waive your preliminary examination?
Yes, ma'am.
Anybody threatening you to do that? Are you sure? It appears that you're threatened the way you looked around. Who's threatening you?
No, ma'am.
Who's making you feel forced to do it? How is the prosecutor forcing you to do it? Talk.
I got to be charged, more charged.
Oh, that if you perceive that they could request to add additional charges? Okay. Well, that's pretty standard. That doesn't force you.
No.
They can only add more charges if the facts that come out support the addition of more charges. If there's no facts that come out through testimony or other evidence that support the charges, then they can't add more charges. They just can't come out the sky with new charges. So if you were thinking that they could just come out the sky with new charges, it's not what it is. That means if we move forward with your exam and the testimony supports additional charges being added, like let's hypothesize here. Let's say there's a testimony and the witness says that the assault happened with a firearm and that there was 3 assaults and not 2. Well, now they can add additional assaults based on that testimony if that's a testimony that the court finds credible. So I don't know if that changes your position as to whether or not you want to have your exam or not.
No.
Okay, you do not want to have the exam still. Okay, and so no one's threatening you, correct? Okay, any promises that are being extended to you to make you feel like you need to give up your exam so that you can access these promises? Okay, and so you're waiving your exam freely and voluntarily?
Yes.
Okay. Your bind over date is going to be March 12th. That's the date the circuit court gets the file from the district court, not a date that you need to appear in the circuit court unless your attorney files a motion. Unless your attorney files a motion for you to be rearranged in the circuit court, okay?
Yes, ma'am.
Okay, it looks like bond was denied in this matter.
Yes, Your Honor.
Okay. That will continue. Any additional matters for the record?
Not from the people.
No, Your Honor, thank you.
You're all set.
Thank you, Your Honor.
You're welcome.